Good morning. I do wish I was here under different circumstances. Indeed, I will tell you, I know many of you are from the East Coast, including your incoming president. So you on the East Coast do not have this requirement in June of getting up at the crack of dawn and logging on to SCOTUS blog at 7 a.m. So you may have experienced it here today, as I did, to learn after 2 months of the court's indecision. So clearly my remarks have been wholly reorganized based on what occurred this morning. And indeed, as I was involved in talking to the media, putting out MALDEF's statement, and other associated tasks. As an aside, we also had to do that with respect to the victory in Fisher versus University of Texas, which coincidentally comes on the same day. But as I was doing all that, I seriously considered not even showing up and not doing my job, because that seems to be going around, and I thought, if they can do it, why can't I? But I thought better of it to share with you my thoughts about the indecision, the non-decision of this morning, and the many inactions that led us to this point, because I think those relate to the political repercussions of what the Chief Justice announced this morning. I begin, of course, with the inaction by the court. It is certainly true, and I'll touch on this in a minute, that we are in this situation because only 8 justices currently sit on the Supreme Court. But having been there in the room for the argument on April 18th and having had 10 minutes of time before those justices, I cannot let this 4-4 go by as though it's simply the result of justices voting their consciences with respect to the law. I think it cannot go without remark, and I hope it will not go without remark, as this decision is, or non-decision is digested, that we have a Chief Justice who, despite his vehement dissent from the case of Massachusetts versus EPA, has voted to conclude that the state of Texas had standing to challenge the president's executive actions announced in November 2014. I know many of you are familiar with the basis for that standing, but to describe it as thin would be unfair to the term. In fact, it's virtually non-existent. The state of Texas granted standing by Judge Hainan on the basis of a single declaration asserting that the flood of recipients of deferred action for parents of Americans would require the Texas DMV. And as an aside, I'm not sure what is so special about the Texas DMV, but I don't think they have a reputation different from DMVs across the country. Nonetheless, the assertion in the declaration was to keep up with demand, something for which few DMVs are known, I'm sure. The state would have to hire hundreds of employees to adjudicate and grant driver's licenses to deferred action recipients. The problem with the declaration is not solely its limited content, not solely its speculative nature. One of my favorite questions in the argument on April 18th was when Justice Sotomayor asked the Texas Solicitor General, why wouldn't you do what DMVs have done for time immemorial and just have people wait in line? Why do you need to hire these new employees? Understandably, the Texas Solicitor General acted as though he didn't understand the question. But the flaw lies not only in the speculative nature and the very limited showing, but in the fact that Texas made its own decision long ago to take on the costs, the injury, the costs of providing driver's licenses to everyone. Now, that's not an unwise decision, and you'll understand why I, as president of MALDEF, an organization founded in Texas, but which has over the years had much litigation against the state of Texas. Its current governor a few months ago said that all we were interested in was collecting attorney's fees. My response to that is to tell Governor Abbott, we collect attorney's fees because we win, and yes, thank you, state of Texas. Throughout the 48-year history of MALDEF, you are certainly one of our top 3 funders, though all of it involuntary. But the state of Texas, in this case, made a wise and fairly common decision to subsidize the provision of driver's licenses to everyone. The legislature concluded that it was far better to have licensed, regulated, tested drivers on the highways of the state rather than to have folks forego that process and drive without licenses because of an unduly high cost. So Texas made a decision to subsidize licenses and then premised its standing in this case on the costs involved in subsidizing the provision of driver's licenses. That kind of bootstrapping is unprecedented. But the effect of the one-line order of today is we now have a Chief Justice who has been, as demonstrated by Massachusetts versus EPA, an extreme skeptic about states' standing to challenge actions by the federal government based simply on the day-to-day governance that states are engaged in. There is simply no way of distinguishing this case from that skepticism. I suspect that the Chief Justice concluded that a one-line order meant that his name wasn't on any sort of decision undermining, whether dissent or decision, undermining his previously well-stated skepticism. Which is why I hope basically he doesn't get away with it. We all have to understand and should call out that the effect of this one-line non-decision is to undermine standing doctrine for all time, to undermine any consistency in the Chief Justice's jurisprudence about states standing to challenge federal action. So the inaction, this pattern, this contagion of not doing your job starts with the Supreme Court. By all lights, those of us in the court 2 months ago believed that the Chief Justice and possibly Justice Kennedy would come out right, at least with respect to standing. And they didn't. It's reflected in a one-line inaction, non-decision, but it has real repercussions. Of course, it's not just the court that has had trouble doing its constitutional duty. We cannot, and I believe that the community will not, excuse the United States Senate for its ongoing refusal to perform its constitutional duty to advise and consent to nominations by the President to the court. There is no question but that we would have a decision. We can all speculate about what the decision and outcome would have been. I'm confident in what it would have been. But we certainly would have a decision with opinions and dissents were Judge Garland to have been confirmed to the court. Now, I will tell you, of course, that anticipating this, those who have a different perspective are already preparing their response. In a media call this morning, a journalist from Breitbart, you all know Breitbart, questioned whether it was possible for a Justice Garland to have heard this case. So the facts are these. The President nominated Judge Garland more than a month before the oral argument in United States versus Texas. Is it inconceivable that a justice could have been heard and confirmed within a month? No. and in fact our expectation should be that the Senate would act with such alacrity when the circumstances, including the unexpected passing of a justice, the pendency of numerous important cases in the court, suggests a need to act quickly on a nominee. So there will be repercussions from this inaction, this non-decision, I believe, for the leadership of the United States Senate that still seems to believe that it gets a one-year furlough every 4 not to do its job because we're in the midst of a presidential campaign. But of course, the inaction does not end there. I think that depending on your point of view, fortunately or unfortunately, the President and his administration will not come out of this indecision without real harm to his legacy, not just on the issue of immigration, but on the issue of executive leadership. This administration failed to act early in its tenure on immigration reform when the composition of the Congress was such as to make it not only possible to act on reform legislation, but to enact it with bipartisan support. And that failure 7 years ago will not go without remark as this indecision of today is digested over the weeks to come. It will also not go without remark that the President postponed a promised announcement of a broadened initiative of deferred action in 2014 to await the outcome of the mid-term elections. And that number of months, many will assert, played a role in putting us in a position that made it possible for today's indecision, non-decision to occur. So there will be those who will argue that those historical instances of not moving forward with his promised commitment and duty on immigration reform and on addressing the broad misapplication and misenforcement of an immigration law has had consequences borne out by today's inaction. But I think that the inaction goes beyond that, and in a few moments I'll talk about what I think has to happen from here. But this contagion of inaction and a refusal to do your job extends much further. And this too will be a part of the reaction to this one-line order today. And it is my hope that it will shine a strong light on the leaders of 26 states in this country who made a decision following the President's November 2014 announcement and have continued to pursue what is wholly political litigation. In this room, we know that what the President announced in November 2014 was not unprecedented. It was not extraordinary. Despite his own misstated ambitions to change the law, change the status, he did not do that. All he did was act consistent with his predecessors, including the predecessor who has the heretofore most ambitious initiative in the area of prosecutorial discretion, Ronald Reagan. We know that what he announced was simply a way of making sure, taking care, if you will, to quote an otherwise obscure clause of the Constitution dredged up by the court in this particular case. But what he did was to take care that there be faithful execution of his exercise of prosecutorial discretion. That is to say, the President wisely concluded that in 21st century America, with thousands of DHS and ICE employees around the country, required to engage in the day-to-day decision-making about enforcement that has real consequences for immigrants nationwide. He wisely, I think, concluded, based on experience, that he could not adequately control the decisions and actions of the rank and file without greater systemization of his exercise of prosecutorial discretion. And in the end, deferred action is just that, a systemization of the discretion that is regularly exercised by rank and file decision makers around the country. A systemization to better ensure that the President's own articulated priorities, not extraordinary priorities, but those acquiesced in by decision makers over many, many years, many, many parties. But a systemization that ensures that his enforcement priorities are uniformly followed across the country. From this perspective, what he did was not extraordinary. And when the state of Texas, joined ultimately by 25 other states or state leaders, filed their litigation in Brownsville, Texas, they did so to test executive authority, to test established presidential prerogative. They did not do so with an eye to the well-being of anyone living in those states, or particularly of those living and potentially eligible for deferred action relief. So when you talk about a failure to perform one's duty, I do not think the 26 states and their leaders will be forgotten, because their actions in continuing this litigation to this point and beyond is not performing their duty to act in the best interests of their own residents, including, in the state of Texas and others, the significant portion of their residents who are family members or are themselves eligible for the deferred action that was announced by the President. So in the face of all of this inaction, you of course understand why I thought I might not just show up today. I would be in the company of Supreme Court justices, governors, Attorney General, and President of the United States in doing so. But what happens from here? Obviously, you all understand that there's lots of strategizing, discussion, calculation going on already. But certainly one thing is true: this is ongoing litigation. What was before the court was only a preliminary injunction. And there are steps that can and will be taken, perhaps in the Supreme Court, perhaps in the lower courts, with respect to this litigation. And I agree with your incoming president that ultimately justice and righteousness will prevail. I tell you, as a career-long civil rights lawyer, one thing you have to learn, and it's not easy in this day and age, but you have to learn, and I learned it long ago, though it was not easy, that even in defeat, you win. And I could cite example after example from my career in civil rights where that has been true. And I am convinced that this is another circumstance where a temporary defeat will result in a long-term victory for civil rights and humane and just treatment of immigrants. That battle will be in court as this case moves forward. It may be in other courts. But in addition, I think my rendition of the failures to act and perform duties will also have repercussions in real action in the future. I come from the state of California, as you've heard, where Prop 187, which you've also heard about and are familiar with, is widely believed to have changed that state for good. The backlash to Governor Pete Wilson's use of Proposition 187, an anti-immigrant initiative unprecedented at the time, to secure his re-election, had real repercussions within 5 years for the politics of California. Now, there are those who would speculate that the presumptive candidate for president in one party may have the same nationwide effect with respect to the Latino community that Proposition 187 had in California. I lead a 501c3 and I have no perspective on that. However, I do believe that whatever the impact of the presidential campaign, there will be real repercussions for the state of Texas that has led this political litigation, and for other states among the 26 with significant Latino and immigrant populations, because they will be held accountable within the next 5 years and beyond for their dereliction of duty in pursuing this political litigation. You will also hear, and they will be legitimate calls for additional action by the administration. Some of them will relate directly to the population that is eligible for these initiatives were they to be implemented, and some will not. There will be legitimate calls for additional changes in enforcement priorities that will hopefully finally recognize that refugees from Central America are refugees like any from elsewhere in the world. For changes in policy that will finally recognize that family detention is an abomination that has no place in this country. And for changes, I hope, that will recognize the President's ability and authority to take action separate and apart from these initiatives to ensure that there is uniform, nationwide compliance with articulated enforcement priorities. From the beginning of this administration, it has been inexplicable to me that the very same government that through the Department of Justice has regularly, though perhaps not as often as it should have, gone to police forces around the country and taken action through litigation and consent decrees to root out corrupt cultures within law enforcement agencies. There should be no mistake but that this federal government and the Department of Justice knows how to change a culture in which line officers believe they can defy a police chief or mayor because they know that their careers will be longer than the tenure of any chief or mayor. This government knows how to fix that situation. I'm from Los Angeles, I can attest to that. I worked with Mayor Villaraigosa as we implemented the consent decree that changed the culture of the LAPD. Why cannot this administration take the learning from the Department of Justice and apply it to ICE and the Department of Homeland Security? It takes a degree of command and control, but this administration can, in its remaining short lifetime, still take the steps to ensure that enforcement priorities are followed by every officer and every office of the Department of Homeland Security and ICE. There is no way of denying the great disappointment, the great fear that will be engendered across this country by the Supreme Court's inaction today. But I think through the steps that I've described and many others to be devised and developed in the weeks to come, the reaction to this failure to perform the court's duty to ensure that Article 3 standing is real, to ensure that political cases have no place in our Article 3 system, to ensure that executive authority that has been exercised throughout history is vindicated, that today's inaction and failure to perform the court's duty will result in real change. Now, I said that I have learned that from each defeat comes a victory. That does not mean that there will not be much suffering and harm in the meantime. California did change, but the state suffered in the aftermath of Proposition 187, although it was prevented by the court system from implementation. There will be suffering, there will be fear, there will be disappointment. But those of us in this room are well situated to address those fears and disappointments with a message of optimism, with a message of commitment to ensuring that the kinds of changes that need to follow will occur. In this room, we have folks who are knowledgeable about one of the most complex areas of law in this country, about which there is so much inaccuracy, confusion, and ignorance from the highest levels. And we can work to ensure that folks understand immigration law and our current system. We can, through that knowledge, inspire change, because I am convinced when people understand the reality of our law, they understand why it needs to change. We in this room also know what it means to have politicized courts. I know in the immigration court system, we see it every day. Judges, immigration judges, make decisions, perhaps too many of them, on the basis of political considerations. Folks in this room understand why we cannot have that particular malady passed on to our Article III court system, including the Supreme Court. There is no place for political cases like Texas versus United States, and I am convinced that despite the setback of today, that working together, the inaction, the indecision will be followed by decision and commitment to ensure that we arrive at not just an exercise of enforcement discretion, but ultimately with legislation that provides this nation with an immigration system that better reflects our constitutional values and principles, recognizes the dignity of every individual, and will provide the justice and humanity to my clients, 3 Texas mothers and millions like them across the country, that was denied to them today by the Supreme Court and the many complicit others in a non-decision. Thank you.